all this video evidence and all this stuff that people are talking about. Okay, so I have to filter from, the real thing from the noise. And I realized that the only person that could give me real answers right now is Tyler Robinson. So how do I get to Tyler Robinson? Well, if I write a letter that I need to, see him in prison, as a journalist, no one's going to allow me to even go, centimeters closer to the gate. So I realized that the best way I can get to him is through a lawyer. So I decided, why don't I get this guy a pro bono lawyer? And I went down to different firms in Utah, asking them to represent Tyler Robinson for free as a pro bono case. And this is where lawyers in Utah told me that, hey, so we are more than happy to do so. And these are average lawyers, your average firms, not the most popular ones in Utah. So they were like, we're very happy to do that for you, Elizabeth. The only problem is we don't have the qualification to do so. We can help you find somebody who does, but we cannot represent him. And then they said something very interesting. Guy named Skordas, who's, by the way, I think there was a mistake made on Candace's part. She said the prosecutor on the case. Skordas is not the prosecutor on the case. Skordas was running as a prosecutor of the state. So as an attorney general, which is a different case, but it's still very unethical for a person who's running as an attorney general in the state to, look for a lawyer for Tyler Robinson, who's a defendant.
Wait, can I just clarify? I need you to clarify
Yes.
what you're saying. So the attorney general in Utah, and what's that person's name?
Skordas.
How do you spell that?
I don't remember the spelling, but Greg, you can look it up. Greg Skordas.
Is it sound like Scordis? Skordas? Is that what you're saying?
Yes, I believe so. Yes.
Okay, and so this person is the Attorney General of Utah. Yes.
He was running for an attorney general position.
Oh, so he's in a campaign.
Yes.
He's in a political campaign to become but what is his job right now?
So right now it's very funny. He has a show. He leads a talk show that I never listened to, but a lawyer in Utah told me that when this whole thing happened, he was the guy who announced in his show that he doesn't believe, and again, this is what the lawyers told me in Utah, he doesn't believe that Tyler Robinson did any of this. And then when I'm trying to find Tyler Robinson a lawyer, I get shut down because the same lawyers tell me that, well, you can't look for a lawyer because Skordas is already on this case and looking for a lawyer. So that was really weird for me and kind of unexplained. Okay, so he can look for a lawyer, but so can I. Like, what stops me from doing the same? By law, I can do that too. It is up to parents and Tyler Robinson himself, because he's, an adult, to pick which lawyer he wants to go with.
So how does this guy who's running for attorney general, is he also a lawyer? His name is Greg Skordas, Skordas. So does he have some kind of government position right now or no?
Well, right now, I'm not sure if he holds any governmental position. We should probably check. I don't know. But what I know is that he had on his website that he was running as an attorney general.
Okay.
So when I checked in with lawyers, because I don't practice law in Utah or in the state, so I checked in with them and they said, well, Elizabeth, like from starters, that's very unethical. So that's where like this whole thing about the lawyer kind of got to me, and I started trying to reach out to these people, like the highest, paid firms in Utah. And not only they got really mad at me that I was doing that one of them actually hung up the phone. Like, I was talking to him and I'm like, hey, I actually have a lawyer from New York who's willing to represent Tyler Robinson. And he's one of the best lawyers in the country, not just in New York, in the country, and worked on high profile cases when it gets to death row. And they screamed on the phone and hung up on me. So I was like, okay.
So how does Greg Skordas become the person who's in charge of picking a lawyer for Tyler Robinson, the accused assassin of Charlie Kirk? How did he get to be in that position? I don't understand. Do you?
I don't know. I know that he was there. I was at the hearing, the first hearing that happened. That was a whole different spectacle, because I live in Utah. So I attend those hearings and I'm always on the case. So I was there, and let me tell you something really weird. So he was there too, by the way. Greg Skordas was there. I think one of the either I don't remember which outlet recognized him, but they said, isn't that Skordas like addressing the judge? And he was there. So I'm sitting in the first row. The whole thing about this hearing was just a clown show. So in the beginning, I thought that this is a high profile case. I'm going to get there early because I don't know what's going to happen, right? There might be too many people. I want the good seats. I want to know what's going on. And it was only like maybe less than 20 journalists altogether. And this is like Charlie Kirk we're talking about. So that was really strange for me. Then they let us in. They warned us that we can't have any electronics, any phone or anything. Like it has to be in our pockets or we would be dismissed. And 15 minutes into the hearing, they went to recess.
Wow.
Yes. 15 minutes. I was like, okay, so we've been here maybe like 15 minutes and you're already going to recess. And what's worse than that is that they told us, well, you can't come back anymore. So you're out. Adios, journalists. Like you go do your thing. I'm like, what's going on here? So that was really weird to me. And then, it just, all the other thing that happened that I can talk about, but I also wrote an email to Nester, which is a current lawyer of Tyler Robinson. I was like, well, maybe she doesn't know. Maybe she hasn't heard about me, like that I've got this lawyer, for pro bono case. So I wrote her an email detailing that I have a lawyer who's willing to help her out for free, who's much more experienced than she is. And I've got no answer back.
The foundation of the American justice system rests on pillars of transparency, vigorous advocacy, and public accountability. The courtroom is envisioned as a crucible where truth is forged through the fire of open debate, where the accused faces their accusers, and where the process itself is subject to public scrutiny. It is a system designed to be messy, loud, and public, for it is in that very chaos that the light of justice is most likely to penetrate every shadow. But what happens when those pillars begin to crumble? When the doors of the courtroom are metaphorically locked, when the voices of advocates are silenced, and when the face of the accused is deliberately hidden from view. The case of Tyler Robinson, an incarcerated defendant in Utah, has become a terrifying case study in this very scenario. This is not a story about the alleged crime, the details of which are often obscured by the very secrecy this article will explore. This is an investigation into the process itself, a process that, from its inception, has been characterized by a pattern of obstruction, unusual procedural decisions, and a wall of silence, so imposing that it has ignited a firestorm of suspicion among independent observers, journalists, and a concerned public. The central, haunting question is no longer about guilt or innocence, but about whether the system is working to deliver justice for Tyler Robinson, or is being manipulated to ensure a specific, predetermined outcome. The alarm bells did not first ring inside a courtroom. They sounded in the office of investigative journalist Elizabeth Lane, whose initial mission was one of simple civic-mindedness, to help secure pro bono legal representation for Robinson. For a journalist with her experience, this was a straightforward task, a matter of making the right calls to the right firms. But from the outset, the legal establishment in Utah seemed to recoil. The first responses were the standard deflections one might expect, polite declines citing busy dockets or a lack of specialization. But as Lane persisted, the tone shifted dramatically. The politeness evaporated, replaced by a palpable chill. On multiple occasions, as she began to explain the nature of her inquiry regarding the Tyler Robinson case, the line went dead. Not with a goodbye, but with a sudden sharp click. These were not accidental disconnections. They were deliberate acts of termination. Senior partners at law firms renowned for their extensive pro bono work, attorneys who had built careers on defending the indigent and the voiceless, were suddenly and unanimously unavailable. The pattern was too consistent to be coincidence. It suggested a deep-seated reluctance, or even a directive, to avoid this particular case. What was it about Tyler Robinson that made seasoned legal advocates, those who routinely confront high-stakes and complex litigation, hang up the phone? What unspoken fear or pressure could cause such a uniform reaction? This wall of silence was made even more ominous by the whispers of a shadowy figure operating in the background. Rumors began to filter through legal circles about a local man named Greg Skordas. Unverified reports suggest that Skordas, an individual with deep and tangled connections throughout Utah's political and legal landscape, had become involved in the process of selecting counsel for Robinson. His exact role remains undefined, his interest unexplained. Is he a well-meaning intermediary, or is he a gatekeeper, strategically ensuring that only a certain type of representation reaches the defendant? The very presence of such an unofficial, yet seemingly influential, figure raises profound and disturbing questions about who is truly controlling the levers of the defense and to what ultimate end. Against this backdrop of obscured backroom dealings, the public-facing legal proceedings began. They were not the dramatic, contentious hearings one might associate with a controversial case. They were brief, perfunctory, and over in minutes. Access for journalists and the public was severely restricted, creating an immediate information vacuum. The usual channels of communication from the courthouse, which typically provide a flow of context and procedural updates, were clamped shut. It was in this environment that the first major procedural anomaly emerged. Tyler Robinson's court-appointed lawyer, a local attorney named Nester, was presented with what should have been a golden opportunity. More experienced, nationally recognized counsel, specialists in cases bearing similarities to Robinson's, offered to step in. They were prepared to provide their services entirely pro bono, bringing their expertise and resources to bear at no cost to the state or the defendant. It was a chance for a robust, vigorous, and sophisticated defense. According to sources close to the outreach, Attorney Nester's response was a resounding silence. He did not acknowledge the offer. He did not engage in discussions. He did not facilitate a conversation between the experienced counsel and his client. He simply ignored it. This behavior defies easy explanation. From an ethical standpoint, a defense attorney's primary duty is to provide the best possible defense for their client. Refusing an offer of free, top-tier legal help is a profound deviation from that duty. Is it a matter of professional pride or incompetence? Or could it signal something more concerning? Some close observers have begun to voice the unsettling theory that Nester is not acting as an independent advocate, but as a custodian, tasked with managing the case along a predetermined path rather than fighting aggressively on his client's behalf. The strangeness then escalated to a new, deeply symbolic level. Plans for the legal proceedings were abruptly altered. An announcement was made that Tyler Robinson would not be appearing in person for upcoming hearings. More disturbingly, it was declared that even when he appeared via video feed from the facility where he is being held, his face would not be shown. He would be represented in the courtroom only as a voice, a disembodied presence, a ghost in the legal machine. The official justification for this unprecedented measure was cited as security concerns, a need to protect the defendant's well-being. But to a skeptical public and to independent investigators, this decision feels far more significant than a simple safety precaution. It is the physical manifestation of the secrecy enveloping the entire case. It deliberately severs the human connection between the defendant and those observing the process. If we cannot see his face, cannot witness his reactions, his demeanor, his very humanity, can we truly bear witness to his trial? Is he being protected, or is the process itself being deliberately hidden from view? This act of concealment fuels the perception that there is something to hide, that the sight of Tyler Robinson might somehow undermine the official narrative. The most powerful and formal tool of secrecy, however, is the gag order imposed on the case. While gag orders are not uncommon and are sometimes necessary to prevent pretrial publicity from poisoning the jury pool, the order in the Robinson case has been described by legal experts and commentators as unusually broad and restrictive. It is not a narrowly tailored instrument, but a blanket thrown over the entire proceeding. It is believed to bind not only the prosecution and defense attorneys, but also a wide range of individuals connected to the case, potentially including jail officials, court personnel, and even family members. This order has effectively muzzled the entire machinery of justice, choking off all official information. There are no press conferences, no clarifying statements, no context provided for the unusual procedures. In the absence of official facts, a vacuum has been created, and nature, and the internet, abhors a vacuum. This vacuum has been filled with intense public speculation, playing out across social media and independent news platforms. A clear division has emerged. One faction urges calm and trust in the system, arguing that the judge and legal authorities must have valid reasons for their actions. They posit that the refusal of other lawyers could be due to the case's complexity and the unwanted media spotlight, and that the gag order is a standard tool to ensure a fair trial. However, a larger and more vocal contingent, fueled by the dogged reporting of journalists like Elizabeth Lane and the collaborative work of online investigators, grows more concerned by the day. The patterns are too consistent to ignore. The blocked legal access, the shadowy influencer, the unresponsive defense attorney, the hidden defendant, and the stifling gag order. When viewed in isolation, each element might be explained away. But when connected, they form a disturbing mosaic that suggests a process not of justice, but of control. The public's role in this drama is crucial. They are the witnesses to a process that seems intent on avoiding witnesses. Their questions, their skepticism, and their demand for transparency are the only counterweight to the oppressive silence. They understand that when a legal process retreats from public view, it risks ceasing to be just. The case of Tyler Robinson has transcended the specifics of the individual involved. It has become a symbol, a test case for whether the foundational principles of open justice can survive in an era of managed outcomes and impenetrable procedure. The truth of what happened to bring Tyler Robinson to this point remains unknown. But the truth about what is happening to him now within the justice system is a story that is still unfolding, and its conclusion will have implications far beyond a single courtroom in Utah.